The big lie about music in podcasting. Hi, I'm Gordon Firemark, the podcast lawyer, and I help creatives in the podcasting industry cover their legal bases and protect themselves and the things that they create. And this is the Podcast Lawyer Speaks, also sometimes known as Legit Podcast Pro. So, what is this big lie that I'm talking about using music in podcasts? Well, here it is. The big lie is that fair use will save you and protect you from liability and other significant consequences related to copyright infringement. The fact is, no, it won't, at least not most of the time. Your episode will get taken down, or you'll get sued for copyright infringement. Your reputation will get damaged. Your advertisers will feel that they've been ripped off because your episode is no longer available after it's been taken down. So just don't. Please don't rely on fair use. Let me start with a little bit of copyright basics, just so everybody understands what's going on here. So in copyright law, authorship of a work, whether it's a song or a poem or a painting or a sculpture or a play or a movie, authorship is ownership. If you create it, you own it, and you own exclusive rights to do certain things with it, those among them being copying, making, distributing copies, performing the work, displaying the work, and making derivative works based on the original thing. So now what happens with music is that most songwriters, when they write a song, they sell the right to their composition to a music publishing company. And then recording artists who record those compositions, they actually pay. If they didn't write the song themselves, they paid the songwriters an agreed rate, a statutory rate, for the right to make and sell records based on that. And the record label actually owns those recordings. These are businesses. You can't appeal to their heart. They are about making money from the use of their work, even if you aren't making money. In their eyes, and in the eyes of the law, you are supposed to pay for the music that you use, plain and simple. So this fair use thing, what is this that you keep hearing about, right? It's thrown around on the internet, in the various forums all over the place, a lot. Fair use is an exception, a defense that was built into the Copyright Act after about 100 years of court-based law addressing it, that tries to balance out the First Amendment free speech rights of creators against the right, also protected by the Constitution, for creators and authors to own and have these exclusive rights that I've described. Now, what the courts did, and the Congress has now made the law of fair use, is to come up with these four factors that you have to develop and analyze. No one of these four factors decides the issue by itself. So the four factors are this: the purpose and character of the alleged infringing use. Is it for educational use? Is it very commercial use? Is it artistic expression? Or is it something more that somehow transforms things? The next factor is the nature of the original. If the two works are basically of the same kind and purpose and character, then they're probably not going to be finding fair use, because one is a sort of substitute for the other. But if they're very different, if there's a big transformation between the two, then you might be more likely to be fair use. Next factor, the amount and substantiality of the portion of the original work that's been taken. The more you take, the less likely it is to be found to be fair use. But it's not just about quantity or time or any of that kind of stuff. It's about the substantiality. So it's qualitative as well as quantitative taking. And the fourth factor is the impact on the market for or value of the original work. Notice that I didn't say whether you, the user, are making money from the allegedly infringing work. That is not a factor here. It may impact that market value thing, or it could have something to do with the purpose and character. But you making money is not a deciding factor at all. None of these is actually a deciding factor. It's a balancing of them all, a totality of the circumstances. So you have to do this analysis for each use every single time. And that's why relying on fair use is tricky and dangerous. And more importantly, because it's a defense, you don't really get a definitive answer until you've been to court, you've had a trial, and a judge or a jury has made a ruling on the case. And that is a big, big deal. No, trust me, you don't want to get sued. Trust me, it's a gigantic expense paying lawyers and defense costs and all that. So what I can tell you is this. Theme music, show opens, closes, transitions, tags, things like that, these are very unlikely to ever be fair use. These are the kinds of things that licensing exists to allow for. You can get music to be the theme of your show or to open or close your show or to cover those transitions. You're hurting the market when you use that without their permission. Now, shows that do talk about the music, they're not just playing it for its entertainment value or as a substitute listening experience, but they actually dissect and criticize and comment and use it to illustrate larger points. Those things are more likely to be fair use. And if you're criticizing the actual piece of music that you're talking about, that kind of criticism is very likely to be fair use. But even then, it can be really, really costly to prove it. And it takes a long time. All the while, your material is not out there being shared. So, look, this is not a great defense to rely on. Sometimes you have to because there's no other way to access the music, but understand the expense and the difficulty. Now, this also only applies in the United States. This is a function of U.S. law. First Amendment is a U.S. principle in our Constitution. It doesn't exist everywhere. And this notion of fair use doesn't exist everywhere. Now, some other countries have variants called fair dealing and things like that. But again, you're relying on these interpretations. So you could get sued or taken down in any country where the work is accessible. So the bottom line, it is a lie when somebody tells you that fair use is some kind of magic bullet that cures you of the need to do the right thing and only use licensed or public domain music. Bottom line, it's a lie. Don't do it. Don't rely on fair use. Now, this, like all episodes of Legit Podcast Pro, are brought to you by the Facebook group. legitpodcastpro.com gets you there. It's free to join. We're talking about these kinds of things all the time, and I hope you'll come and join the group and bring your knowledge and information, not just your questions, but your knowledge and information. And Rosie is rejoining us here. Okay. So I hope that you are getting value out of this, and I hope that I will see some of you out there at Podfest next week. I'm recording this on May the 19th, and next Wednesday, the 25th, 26th, 27th, I'll be in Orlando, Florida for Podfest Media Expo. If you're watching it after that, go to the next one. These are great conferences, these events, and if you're going to consider yourself to be a podcasting pro, a pro in the sense of doing it well, doing it professionally, not necessarily to make money, but if you're going to be a pro, you owe it to yourself to attend these kinds of events and learn what you can, meet other people, and be a part of the community. So I hope you'll join me. And that's it for me. I'm Gordon Firemark, the podcast lawyer, and I'll see you again really, really soon. Have a great day.